Rehabilitation Committee hearing. We will be hearing 6 bills today. I may pause when I get a critical mass of members here to make some general announcements, and I will be definitely changing the order of the bills on the hearing schedule today. So if you're old enough to remember, which no one is, but except me, Mitch Miller in the 50s had a television show. It was like karaoke on television, and you followed the bouncing ball and you could sing along with all the standards. It was my favorite show. Anyway, you're going to be following a lot of bouncing balls today, and we'll probably be doing some hybrid bills. I see Senator Braun is here, but some of the people that want to testify on your bill are not here yet. So I'm going to go ahead and invite you forward, and we will get the staff briefing on your bill and get your assessment of the need for it, and we will come back and get that public testimony later to accommodate your time. Allison.
Madam Chair, members of the committee, Allison Mendiola, committee staff. Before you is proposed second substitute Senate Bill 5338. Wait, I can't read my own writing. 5533, there's a lot of bills today, which has to do with the certificate of improvement in instances of child abuse and neglect that you will recall we did here last year. There is a new version in front of you, which is, as I mentioned, a proposed second substitute. And what I would do is just go ahead and brief summary and then go over what is different from last year. So again, this is a bill that has to do with the creation and issuance of a certificate of improvement when a person who has a founded finding of child abuse or neglect, or an individual whose child was found to be dependent, believes they have been rehabilitated and should not be prevented from volunteering or working in specific environments based solely on that founded finding or dependency. First, the bill no longer applies to school settings. DCYF basically and the secretary are directed to develop and implement a process for issuing CPIs, which should be issued if, on a more probable than not basis, the requester has the character, suitability, and competence to care for children and meets other requirements as set forth in the bill. This would apply both in the context of specific volunteering and employment. There are changes throughout the bill which are some of them are technical and clarifying in nature. Essentially, a CPI could be used in the following situation: unsupervised access to children, DCYF licensing to provide childcare and early learning services, unsupervised access to vulnerable adults. This could be through nursing homes, assisted living facilities, adult family homes, and long-term care facilities. And providing in-home care services involving unsupervised access to persons with physical, mental, or developmental disabilities or mental illness or vulnerable adults. There is a delayed effective date of January 1, 2021. And again, the bill provides for specific requirements for getting the CPI, when you would not be eligible to get one. And then again, there is an appeals process laid out in the bill. A fiscal note was requested and has not yet been received.
Did we ever get a fiscal note on last year's bill? Do you remember?
Yes, but it is in my big file. I can look it up and then speak to it in a minute.
It would be good to at least compare it with whatever we get this year. So thank you for that.
Chairwoman Durham, could I just ask a staff question?
Question for staff.
My question is around the alignment of, say, standards and such around unsupervised, unmonitored contact with our state and federally funded programs related to how that would work with the CPI and DCYF. I mean, do you know what I'm saying? It's kind of like, would they be aligned standards, or if we have those standards in programs that don't allow volunteers, not school districts, but other programs that we're receiving state or federal dollars from?
I will have to get back with an answer if someone else isn't able to answer that.
Looks like we will be hearing from the department.
Oh, okay,
DCYF,
thank you.
So, yeah. Senator Braun.
All right, thank you, Madam Chair and committee members, for hearing this bill again. John Braun, State Senator for the 20th Legislative District. And as Allison said, this is a bill we heard here last year and passed it out, I think, unanimously, and also went through Ways I got tripped up on the floor. Hopefully we can go further this year. There's some you could call improvements or changes to the bill. That's mostly both to address some concerns we had from some of our colleagues on the bill, in particular in K-12, and we've made that change, and also to address some new developments from a lawsuit with folks having access to doing this type of work. So it helps. Not only do I think this is a good thing to do for many of our citizens who have had difficulties in the past but have rehabilitated, and this would allow them the opportunity to volunteer or work with some reasonable vetting that seems appropriate, and some supervision in some cases. But I think it's a good balance that keeps allows folks to be involved as they choose and to move on from past difficulties, but also keeps our citizens, in particular our vulnerable citizens, safe and well looked after. So happy to take any questions. Thank you again for supporting the bill.
I'm thinking it was your bill last year where we heard testimony from someone who desired to provide in-home care services for his mother and couldn't qualify under the existing law. And I think that was pretty compelling testimony for that. So I'm sorry we didn't anticipate the pushback we got later in the bill process, but I'm glad we're addressing this again this year.
Yeah, we did have one of my constituents came up and testified last year, and they're available. They think if we can get to the House, we'd like to have them come up and testify. Since they'd already been before this committee, we thought it'd be good to have them go if we can get all the way to the House. And I meant to follow up. I do have the fiscal note from last year. It was roughly $1.5 million per biennium last year, so we'll watch that. I'm sure this is going to have to go to Ways, and I'll keep a close eye on that and see how that changes, and if it's reasonable, if there's things we can do about that.
Great.
All right. Thank you very much.
Thank you. We're going to hear the public testimony a little bit later as people arrive from hearings over in the House. So do I have any other senators here? No, I don't see any that are. We're also going to push back Senator Cleveland's bill. She'll be arriving late to committee. So you ready, Senator Lynn, of yours? Okay, why don't we move on to Senate Bill 6507. And 6507 concerning legislative reporting requirements for certain Department of Children, Youth, and Families programs. Allison. Hello.
All sit together. Madam Chair, members of the committee, before you, Allison Mendiola, committee staff. As you mentioned, before you is Senate Bill 6507, sponsored by Senator Nguyen. This is DCYF request legislation and has to do with DCYF and outcome measures that were put into place when DCYF was created by the legislature in 2017, that enacting legislation provided outcome measures that are to be updated and reported on annually. So under this bill, beginning September 1, 2020, and no less than annually, DCYF must report to the legislature an examination of engagement, resource utilization, and outcomes for clients receiving DCYF services and youth participating in juvenile court alternative programs funded by DCYF. The data in this report must be disaggregated by race, ethnicity, and geography. This report must identify areas of focus to advance equity that will inform DCYF strategy so that all children, youth, and families are thriving. Metrics detailing progress towards eliminating disparities and disproportionality over time must be included. Lastly, the existing outcome measure of reducing racial and ethnic disproportionality and disparities in the system involved children and youth is changed to eliminate. Be happy to answer any questions.
For Allison? None? Go ahead. Can you make a
Thank you.
statement for us?
Yeah, thank you, Madam Chair. This is what we call here in the legislature a good little bill, where we're just really building upon the work that was done previously to give us more information to make informed decisions for DCYF. So I urge your support.
All right. We got anybody signed up?
Oh, yeah, we have one person testifying with DCYF, Allison Kretzinger.
Thank you.
Good afternoon, members of the committee. Allison Kretzinger, Government Affairs with the Department of Children, Youth, and Families. Thank you, Senator Wynn, for sponsoring this good little bill. We agree. This is really about modernizing the way we report on our outcomes and our data. We have some reports in statute, both in our juvenile justice and juvenile rehab space and our early learning space, that are annual compilations of lots of data that comes in written form a year after the data is relevant, and we want to shift and pivot some of that data to online dashboards in an effort to increase transparency and efficiency that are more user-friendly, that are available in real time, and also compiles a number of reporting requirements and shifts to an entire agency report focused on equity, like committee staff described so well. Good little bill, no fiscal impact, reallocates current resources to report on our work better and more efficiently and more transparently so we can be held accountable to our outcomes. We look forward to your support.
And so this includes all of your contractors out in the field too, I would assume.
Right, they'll be impacted, yep, by the
So I don't know if you've done focus groups with them, or how are they feeling about sort of this shift, this more dynamic?
Yeah, we did some stakeholder engagement over the interim months as we developed the agency request legislation, and overall supportive. They think the shift to more real-time and transparent data is helpful and a good shift, as well as a specific focus on a larger equity report that forces us to collect and disaggregate data by race and ethnicity is a good move, as well as then some smaller reports that drill down and focus on how are we supporting providers who speak multiple languages or are from our refugee and immigrant communities, for example, for families and providers experiencing the system. So by far, stakeholders have been supportive of the process and the shift.
So as you move through this, if you become aware that a subcontractor or a contractor is having IT challenges implementing this change, will you be able to assist those organizations in sort of getting up to that technological level that you need them to be at?
We should. We see this as a first step in pivoting a lot of the data over time. This will take a few reports and move them that we have the data for, that we have implemented some dashboard work around, and then we hope to expand it broader. This right now is just specific to the juvenile justice and the early learning space, but hope to learn how this works and be able to pivot and expand broader over time.
I was just thinking about the juvenile justice space. If you've got an organization that we're providing funding to that is, for instance, engaging the volunteer support of mentors, sometimes getting data back up that stream is a little challenging. My own personal experience in nonprofit work speaking here, but so I guess that would be something I'd like you to watch out for is making sure that they have the IT support and hardware that they need to actually meet those deadlines.
Absolutely. Yeah. Thank you.
Any other questions? Great.
Nope. And then we also had two people not wishing to testify, Don Raines with Treehouse and Neil Beaver with the Washington Defenders Association, the Washington Association of Criminal, both in pro.
I don't think it's Washington State
I
Association.
know, it's kind of weird.
It's the way it cuts it off. I think
I'll just read the teleprompter.
Defense lawyers or something like that at the end, not criminals.
Washington Association of Criminal Defense Lawyers.
Yeah, it's just that the space on this, talk about IT problems. There we go. Now the Washington Association of Criminals. Okay. Okay, so with that, that's a weird one, yeah. So with that, we'll close the hearing on 6507, and we will move now down to 5744 concerning, wait, are we expecting Senator Dingra to come? Does anybody know? We are expecting her, okay. Or she's here. No, she's not here. Okay, we'll wait on that. Let's on, is Darnell coming? No, okay. 6422, establishing the Family Connections Program. And actually, I'm also looking out in the audience, and people may not be here that want to testify on that, but we will check.
Madam Chair, members of the committee, Still Allison Mendiola, committee staff. Before you is Senate Bill 6422, sponsored by the Chair, Senator Durneal, as she mentioned. So this bill creates the Family Connections Program with the goal of connecting, when appropriate, a parent with a dependent child with the individual with whom the child is placed. It's the stated intent of the legislature that this program will put children first, work to reduce family trauma, and support the child by helping adults learn, share, and work on understanding to how best to support the child together. So beginning September 1, 2020, DCYF is to contract with an external organization or organizations to implement and operate the Family Connections Program. The program will operate in one location in Eastern and Western Washington. Families can be referred to this program by a caseworker, a parent ally, an attorney, a guardian ad litem, a parent, I said that already, an Office of Public Defense social worker, or the court. After receiving the referral, the program will determine whether an in-person meeting between the two parties is appropriate, and then see if the parties are willing to meet. And if so, they will make a referral to the Family Connections team. This team includes a parent ally and an experienced caregiver. A parent ally is currently known in statute as a child welfare parent mentor, as you may recall from the Parents for Parents program, and it is also used in the Child Welfare Housing Pilot Program. That term is also used, which refers to a parent who successfully resolved the issues that led to the parent's child into the care of the dependency system, resulting in family unification or other permanency outcome, and who has an interest in working collaboratively to improve the lives of children and families. An experienced caregiver is defined in this bill, and it means an individual who has received a foster family home license or is an individual who cared for a child removed from his or her parents and who has a kin relationship to that child. The parent ally contacts the parent to prepare for the meeting, and the experienced caregiver contacts the caregiver. The team convenes an in-person meeting and provides ongoing support following that meeting. And if the program determines that this meeting would not be appropriate, the team will facilitate an exchange of information in another way. This could include written messages, phone calls, or video conferencing, for example. The program is to routinely evaluate whether in-person meetings should occur. DCYF is to collect data and measure outcomes for families engaging in this program. And then by September 1, 2021, DCYF is to submit a report to the legislature regarding this program, which expires on June 30th, 2022. And as I mentioned, the definition of parent ally is revised in both the Parent for Parent program and the Child Welfare Housing Pilot program. So fiscal note has been requested and not yet received.
Questions for Allison? Thank you. I'll just speak ever so briefly to the bill. There are a lot of people that want to speak on this. I want to say I'm just very excited about the turn that we're making as a state to recognizing that reunification is not just possible, but it's preferable. And I have had a number of opportunities to see this happen, see that rejoining of a biological family. And, you know, I'm reminded of stories children have told me that they knew it was bad. They knew it was bad at home, but they will never, ever stop loving their parents. And so it's really incumbent upon us as a state to change direction in this way and to recognize the skill sets that parents can achieve or re-achieve in their lives. And so this particular bill addresses the way that people affected by that process could be of assistance to others as they try to maneuver to the best outcomes for their children. I've seen it work in baby court, for instance, where birth families and foster families have been unified in their assistance to the birth parents. And everybody's looking out for the best interest of the child, and that really is important for us to put first. I want today to tell you just ever so briefly about a friend of mine who died this week. Julian Bray was an assistant attorney general for the state of Washington out of the Tacoma office. And Julian was really one of those guys that was responsible for making drug court work through the process of working with families and really doing intensive case management, really. Even though he had a law degree, he was ever so much the social worker as well. And just an all-around great guy. And Julian died this week of brain cancer and as a young man. And I just wanted to mention him today because there are a lot of people out there in the system who have dedicated their lives to helping children and in this space and other spaces. And this bill before us today is exciting. And I look forward to hearing all the testimony on it. So any questions anyone has? Great. Oh, I see Senator Dingras here. So we're going to follow that bouncing ball one more time. And we are going to bounce back to the staff report and the prime sponsor report on Substitute Senate Bill 5744 concerning commercially sexually exploited children. And this will be a hearing on the proposed substitute. We've seen this before, but we're delighted it's back.
Madam Chair, members of the committee, Allison Mendiola, committee staff. Before you is Senate Bill 5744, sponsored by Senator Dingra. And before you is a proposed second substitute. As you mentioned, you did hear this bill last year, and this bill has to do with creating receiving centers for commercially sexually exploited children and decriminalizing prostitution for minors. The draft before you has, the bill before you has a number of changes, which I will briefly review. The intent section is modified. Secondly, DCYF, instead of the Office of Homeless Youth Prevention and Protection Programs, will administer the funding for the receiving centers, which are subject to appropriations. Services at the receiving centers are delayed until January 1, 2021. And again, this bill does require that there's a receiving center, one in Eastern Washington, one in Western Washington, and the bill specifies that they utilize existing services and not require the construction of new facilities. It is specified that individuals eligible for receiving services at the receiving centers include children ages 12 to 17 of all genders who have been or are at risk of being commercially sexually exploited. It removes requirement that the receiving centers provide licensed residential substance use disorder and mental health treatment up to 1 year at the same time with the short-term evaluation function. So they can still do the short-term evaluation function, but the long-term is not included in this version. The bill also requires that law enforcement transport a child to a receiving center or to coordinate with the DCYF CSEC liaison, which is a new position created in this bill. There would be one in each region and then also a program manager to oversee this work. It establishes the authority for law enforcement to take into protective custody a child who is or is attempting to engage in sexual conduct with another person for money or anything of value for the purpose of investigating the individual who may be exploiting the child and deliver the child to an evaluation and treatment facility, which includes receiving centers. Requires DCYF to provide services to support CSEC, including the positions I just mentioned, and requires that the CSEC statewide coordinating committee convene a meeting related to the role that child advocacy centers have in responding to this and provide recommendations to the Department of Commerce by October 1, 2020. And then the bill also requires that Commerce provides a report to the legislature by December 1 of 2020 that includes an inventory of all child advocacy centers, a description of services provided, and recommendations for expanding the use of them in this for this work. Lastly, the substitute delays the effective date for sanctions decriminalizing juvenile prostitution until January 1, 2024. And we do not have a revised fiscal note at the moment, but I did look at last year's, and it was estimated at $7.7 million biennium. The cost would obviously be different in that one, there's not the construction of a new facility using an existing facility, and it's not the 1 year treatment. But then at the same time, we are adding a couple positions to DCYF. So I don't have an estimate of that at this time.
Okay. Questions for Allison? Great. I should have told Senator Dingras she could come up and sit with Allison as she's made that report.
Thank you, Allison.
Thank you.
Good afternoon, Chair and members of the committee. My name is Manka Dhingra. I'm the state senator representing the 45th Legislative District. Thank you so much for hearing this bill once again in your committee, and I really want to thank you for passing this out last session unanimously out of this committee. While I don't like the fact that the bill didn't pass last year, I really do think what you have in front of you is an improved version. What I'm very excited about is the liaison positions that have been created through DCYF. And I'll tell you the big overall vision here. We as a state have to be very, very clear. Are these individuals victims of crime or are they perpetrators? And we have to pick one. You cannot charge them as defendants or treat them as defendants and say they're victims. These are our children under the age of 18 who are being sold. They are victims. And this is what this bill clarifies. But we also want to be thoughtful and deliberate on how we go through this change. And that's why there is a lengthy period of time before it is completely decriminalized. But that is the right policy. We know there are children. So what this bill does is really make sure that we have a system in place where the children are then taken to a center where they can receive the services and treatment that they really should be getting. The beautiful thing about having the liaison position is that it is not, the burden is not on law enforcement to be that connection. They can have the liaison person through DCYF who will then make sure that the services and are met or is is responsible for the child. And that is what we want. We want DCYF to step up and take care of these children. Law enforcement will say they're very concerned about the decriminalization. And I will tell you as a prosecutor, yes, that is a concern. The concern is it makes it a lot easier to investigate crimes when you have, when you say it is a crime to be a child prostitute. But this is what we have to do in the legislature, is really figure out what is the right policy. And law enforcement has lots of other tools. They have other tools that they can use in order to get to the same results. And this is the time when we have to make sure we're using these tools. And I'll give you the example of when I was still a full-time prosecutor, and we had a Supreme Court decision come out about how we can prosecute domestic violence cases. And at that time, we were horrified. We're like, how are we going to do this? We figured out a way. And that's what this bill does. It sets up the support, it sets up the structure, and then gives law enforcement the time they need in order to figure out how we're going to do this body of work. So this is an extremely deliberative process, and no one here is going in with their eyes closed. We understand the consequences of a shift in this policy, but it is the right policy, it is the right thing to do, and we will have to make sure that we are providing the support and services that these vulnerable children need. And I'm more than happy to answer any questions you may have.
So on the date of implementation pushed out to 2024, what was the date in the bill last year?
Last year, I know we've changed the date 3 times. When I had changed it out to 2 years, then we went to 3 years, and now we're up to 3.5, 4 years. And it really speaks to how willing we are to make sure that everyone feels comfortable with the direction in which we're going. And that is also why the liaison position is created, is to really collect a lot of that data to see what is it that we're looking at. And we have the ability to, the CSEC statewide coordinating committee is going to be getting updates on how this is being implemented. So say in next year, if there's a case that comes up, we have the ability to really think about what was done, what could have been done, what are the barriers to prosecution, if they're really relying on criminalizing the victim in order to make their case, what other mechanisms can they use? And there are other mechanisms, we just have to get used to doing it. And so that
of the perpetrator.
I'm sorry?
The prosecution of the perpetrator.
Well, right now, the victim can be prosecuted as well.
So do we have numbers on that right now? We don't, because we aren't collecting that from jails at this point or local courts.
Correct, and that's because a lot of the jurisdictions do not charge the juvenile. And so we don't have data because These juveniles aren't being charged. What this does is with the liaison position is we will actually be collecting data. And so with the date being pushed out for as long as it is, we will have data, we will have information, and we're going to have a feedback loop where we're going to continue working with law enforcement to really make sure we understand what is happening and how it's happening.
So I'm trying to imagine way in the future, like let's say 2025, when a legislature convenes and someone has knowledge of someone who was arrested for prostitution as a minor during this intervening time between our passage of the bill and that full implementation, coming back and saying, will you please expunge my record and get this off my record, and can I take advantage of treatment services now, and that whole thing. I mean, there could be a whole array of services. Not maybe they wouldn't need the safe harbors in 2025, but I'm worried about pushing off the decriminalization, quite frankly, because absent the data to the contrary, our assumption at this point is that children are being arrested and children will have records that will be associated with this that could follow them for a very long time.
Actually, the data we have is they're not being charged. So there's nothing on the criminal record because their charges are not occurring. While they may...
Is that because we aren't getting information from courts, or are we...
No, the decision has been made not to charge these individuals, these children. So while the process is that if there's a sting operation or if they come across a juvenile who is being trafficked, they arrest, and I'm putting quotes for people behind me, they arrest that individual so they can do a search incident to arrest, they can detain the person, gather evidence, but that arrest does not result in criminal charges. So that is what we are seeing over and over again. You're going to hear that from law enforcement, that juveniles are not being charged.
Okay.
So that conviction is not occurring. What we're trying to get rid of is even that arrest in order to gather evidence. Mm-hmm. And that is the policy that we as legislators really have to make. We don't arrest adult victims of sexual assault when they report to the hospital because we want to collect evidence. Mm-hmm. And it's the same concept here. We shouldn't be arresting juvenile victims of sexual assault because we want to collect evidence. So the policy is what we have to make sure is right, and this bill has the right policy. And I agree with you. If we could make it effective next year, I think a lot of people would like that. But this is where being deliberate and making sure we're not harming children or in any way having unintended consequences is the reason why we're delaying implementation, because we do want to be thoughtful. This is a very vulnerable population. If we are making the shift to intensive treatment, we want to make sure that we're doing everything we can to really take care of them, and we're not inadvertently creating a larger market for having juvenile sex trafficked, juveniles who are sex trafficked.
Great, thank you very much. So we'll go ahead with the rest of the hearing here for this one, I think, absent there being any other
questions?
Prime sponsors here.
Thank you so much.
Thank you, Senator Dingra. I'm going to warn everyone, because we have a couple of bills with a very large number of people who want to speak at them. So we are going to go to a 90-second testify time period. I know that'll be hard. You'll get to that red light and you'll say, no, it can't be so. And I might be a little bit lenient, but let's try it. This is our first time utilizing the dreaded time limiting machine. But you'll see these lights come on when you're testifying.
For the first panel we'll bring up will be Paula Reed, Shoshana Weinberg, and then Jim Theophilus.
Okay. I don't need that. Okay. We don't know what the colors mean on our electronic form. If staff can tell us sometime. Was that? Yeah. Oh. So. Find out. Jim, you're special. You're in a special color here, just FYI.
Is that the 2-minute color?
No, it's the 92 second. Okay, go ahead, Jim. Or who is the
Good
person
afternoon,
called?
Madam
Oh,
Chair,
Okay.
members of the committee. My name is Jim Theophilus, and I'm the founding executive director of Away Home Washington. We have a mission to prevent and end youth and young adult homelessness across the state. On behalf of young people and the families and communities who love them, I'm here to strongly encourage you to pass Substitute Senate Bill 5744 out of committee and give our young people some hope. Of all the young people I've worked with over the 40-plus years, no group is more vulnerable or traumatized and has devastating lifelong impact than the adolescent who is sexually trafficked. I have had young girls and boys describe the routine of having to engage in sex multiple times a day with strangers, only to turn all of the money over to another adult who's exploiting them. The stories of being forced to take drugs so that their pimp or trafficker can ensure they are addicted and further dependent upon them. Speaking of the word dependent, as a licensed mental health chemical dependency counselor, I previously was the director of King County's mental health detention facility, and my experience is consistent with the data, which is that many of these young people are also legal dependents of the Washington state foster care system. In fact, many believe that our national and state failure in the foster care system with adolescents has resulted in the foster care system being a recruiting ground for pimps and predators. And like all data, youth of color and LGBTQ youth are overrepresented in this. I see the light. I'm trying. When young people at Away Home Washington, we have a term, yes to yes. When young people say, yes, I want help, their local community and the state should be able to say, yes, come inside for safe housing. Senate Bill 5744 is a positive and powerful start so that we as a state can begin to say to our young people who want to escape this life, yes, we see you, we care about you, come inside. I encourage you to do pass. Thank you.
Paula?
Good afternoon, Chair Darnielle, members of the committee. My name is Shoshana Weinberg, and I'm testifying today on behalf of the Washington Coalition for Homeless Youth Advocacy in support of Senate Bill 5744. I want to thank you for passing this bill out of committee last year and hope you will support the important changes in this year's substitute bill. 10 years ago, Washington positioned itself as a leader in the nation in its state efforts to combat human trafficking. We passed our safe harbor legislation in 2010, which mirrored the language in the Federal Trafficking Victims Protection Act, TVPA, and defined young people under the age of 18 who perform commercial sex acts as victims of sex trafficking. But our safe harbor legislation did not go far enough. It failed to reconcile the core contradiction within the TVPA in that minors can be legally defined as victims of sex trafficking and at the same time be criminally prosecuted for the sex crime of prostitution. As of 2019, there are 30 states in the country, as well as DC, that have passed some version of safe harbor legislation that diverts, exempts, or immunizes young people from prosecution of prostitution, and our state is not one of them, unfortunately. So we ask for your support in ensuring that the state treats victims of trafficking as the victims they are and not as criminals, and that means not just exempting them from arrest and charge, but investing in an alternative system response that is therapeutic, victim-centered, and lives outside of the criminal justice system. We hope you support this important bill. Thank you.
Perfect. Thank you.
Good afternoon, Madam Chair and members of the committee. I am Paula Reed. I'm the Executive Director of the State Chapter for Children Advocacy Centers in Washington, and I'm here to testify in support of Senate Bill 5744. Commercial sexual exploitation and sex trafficking of children are forms of sexual abuse. As you are aware, these children are not criminals, but rather victims who need our help to escape the dangerous lives they experience at the hands of traffickers and predators. I support 5744 because it helps move us in the right direction with a phased-in approach that will strengthen our state's response to CSEC victims. RCW 2644-020 defines CACs as child-focused facilities that coordinate a multidisciplinary response to the investigation, prosecution, and treatment of sexual and other types of child abuse. There are 17 accredited and 5 developing centers in the state of Washington, and we are currently working to expand to the 7 remaining counties that currently are not served. 5744 encourages collaboration to facilitate an effective response, and we are pleased to see the victim-centered, trauma-focused approach utilized by CACs is recognized as an important resource in creating solutions to this problem. CACs are a national model in responding to child abuse across the country, and they are actively involved in response to CSEC with local community partners. Section 10, subsections 1A and 1B requires a statewide coordinating committee to convene a single meeting with CACs related to the role that they could play in responding to and supporting sexually exploited children, and says that the single meeting must include representatives from CACs. While individual CACs bring extensive experience and expertise to this process, the state chapter represents the entire CAC network, and we would ask for an amendment to the bill indicating that the executive director of the state chapter for Children's Advocacy Centers of Washington, or his or her designee, be added as a core member to the statewide coordinating committee to fully contribute to this effort. Thank you.
Questions? Thank you so much. Next, we'll bring up Lily Corey, Nancy Shapiro, and Leslie Briner.
While they're coming up, I will say that the committee did take an interim tour, and we did go to a child advocacy center and where forensic interviews were completed, and very much appreciate the work of the CACs in our state. And everybody is pro. I shouldn't have mentioned that earlier. Oh, there's a couple of others later on. We'll find out if they change to a pro. Who's starting here? Katie? No. Who said no?
Anybody? Yeah.
Anybody.
I'm happy to start. Good afternoon, Chair Darnielle, members of the committee. My name is Nancy Shapiro. I'm here on behalf of the Justice for Girls Coalition of Washington State in support of Senate Bill 5744 because we believe it can favorably impact girls who are at risk of becoming court involved. As you likely know, most girls get involved in sex trafficking when they run from chaotic, unhealthy, and abusive situations. Running away is a behavior that can often lead girls to being trafficked. Although trafficking affects all youth and the total number of girls who are victims of domestic sexual exploitation and sex trafficking is unknown, it is clear that the vast majority, 76% of arrests of youth for prostitution involve girls. These girls are not criminals, and as a state, we must continue to shift policing practices towards treating trafficked girls as victims, not criminals. Washington State currently offers some protections for girls who are trafficked, but we must take additional measures to expand protections for girls in the substantive ways that this bill addresses. In addition to the trauma a girl can face when arrested for being trafficked, charging her with a crime and engaging her in the juvenile justice system is an added trauma. In Washington State, females are already more likely to report having 3 or more adverse child experiences as compared to males. We don't believe there is a need to add further trauma to the childhood of these young people by arresting and punishing these young women. These are some of the reasons that we support the bill, and we urge you to pass it out of committee. Thank you.
Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Lily Corey, and on behalf of the Center for Children and Youth Justice, we submit the following testimony in support of Senate Bill 5744. Since 2011, CCYJ has been working to build and sustain a statewide, coordinated, and victim-centered response to the commercial sexual exploitation of children in Washington. We began by spearheading the development of the Washington State Model for Protocol for CSEC. Upon finalizing the model protocol, we implemented in partnership with 5 county-wide multidisciplinary CSEC task forces. We have since grown to support 12 task forces covering approximately 85% of Washington by population. While we cannot speak on behalf of our partners on this bill specifically, CCYJ's work with them leads us to the conclusion that this is the right time for this legislation. What we appreciate most about Senate Bill 5744 is that it recognizes fully that CSEC and youth victims and provides the critical needed services. Senate Bill 5744 addresses a critical gap by creating 2 receiving centers as well as designation of liaisons. We have heard loud and clear from our partners, we need these beds and high level of services. Thank you for the opportunity to submit this testimony. Please do not hesitate to contact CCYJ with any questions.
Good afternoon, everybody. Thank you, Chair Darnielle and members of the committee. My name is Leslie Briner, and I am a national subject matter expert on the issue of child sex trafficking. I'm here representing youth care in strong support of substitute Senate Bill 5744. In the year 2000, Washington State became the first state to pass any form of human trafficking legislation. Our state's innovation and commitment to protection and justice for victims of trafficking helped usher in a national movement, yet there is still much more to do. 20 years later, Washington State has fallen a bit behind the nation by failing to protect children from arrest and prosecution for the crime of prostitution and provide comprehensive statewide victim-centered responses to child sex trafficking. And it's time that Washington State became a true safe harbor state. When we began this process, we listened very carefully to the needs and concerns of people in the criminal legal system, social service providers, child welfare, survivors, and stakeholders. This, by all accounts, is a complex problem that needs a complex set of solutions, and that is what this bill seeks to accomplish, with its 3 main components of eliminating arrest for anyone or prosecution for anyone under the age of 18 for the crime of prostitution, establishing the mandate and funding for the receiving centers, and creating the capacity and infrastructure within DCYF. History is riddled with examples of horrific abuses that were legal until leaders and activists changed the hearts and minds of the people and transformed those conditions of suffering and injustice. I've been on the front lines of this movement for 15 years, and I deeply believe that criminalizing children for prostitution under any circumstance, for any reason, is morally wrong. It is time that Washington right this wrong and provide a true safe harbor for victims of sex trafficking, and I urge your support of this committee of Senate Bill 5744.
Thank you so much. Appreciate it. And Lily, welcome back to this Washington State. Next up, we'll have Emmy Koyama, Lisa Taylor Lopez, Darren Dorsey.
And while they're coming up, Leslie, you brought up a good little historical reference to how long Washington State has been involved in this legislation. It is 20 years, and Representative Velma Valoria and Senator Jeannie Cole-Wells were instrumental in bringing these very tough issues before the legislature, and I was pleased to have been here at that time and shared that victory. Thank you.
Good afternoon, Chair Darnielle and members of the committee. Thank you to Senator Dingra and co-sponsors for their work on this bill. My name is Darren Dorsey, and I'm here representing the Washington Coalition of Sexual Assault Programs, also known as WCSAP. Thank you for the opportunity to testify today on Senate Bill 5744. WCSAP is a nonprofit organization whose mission is to unite agencies engaged in the elimination of sexual violence through education, advocacy, victim services, and social change. We represent over 100 sexual assault service providers, culturally specific and tribal programs, and student, individual, and agency supporting members. Minors who are victims of sexual exploitation are not criminals. And Senate Bill 5744 is an important step in ensuring that we as a state do not add to the trauma that these young survivors are already experiencing. Additionally, by establishing trauma-informed centers where minors can receive support that they need, this bill provides alternative paths for young people who may otherwise end up in the criminal justice system. It will also give us the information that we need in our efforts to prevent child sexual exploitation by compiling information on young people who are experiencing sexual exploitation. The Washington Coalition of Sexual Assault Programs supports Senate Bill 5744. Thank you.
Hello. My name is Lisa Taylor Lopez, and I am the decriminalization core advocate of the Sex Workers Outreach Project. We are a nationwide, indeed global organization of sex workers, current and former. We certainly support this bill. We certainly support not treating minors in the sex trade as criminals. 2 points. We think that decriminalization should happen now, not after 2 receiving centers are built. And also, in addition, and this was spoken on earlier, we believe that social workers or something of that nature are better capable of building relationships with impacted youth, and that will have better outcomes than having police detain youth in the sex trade. We understand the fear of impacted youth falling through the cracks, and we believe the outreach of social workers would be much better to do this work. The police are seen as a threat by most people in the trade, regardless of age or circumstance. Thank you.
Thank you, Madam Chair and members of the committee. My name is Emi Koyama, and I'm the director of the Coalition for Rights and Safety for People in the Sex Trade, a coalition of 21 community organizations in Seattle, King County area. As a former street youth who did what I had to do to survive, I welcome the provision of this bill that finally ends the criminalization of minors engaged in the sex trade. Personally, I would like to see people of all ages stop being arrested and prosecuted for engaging in prostitution, because nothing changed for me at midnight on the day I turned 18. But that will probably take more time and conversations, and youth cannot wait until that broader conversation is settled. Neither can youth wait until 2024, the year this bill proposes to make the crime of prostitution inapplicable to minors. Last year, when this committee heard this earlier version of the bill, 25 states and District of Columbia had some legislation, some kind of a law protecting youth from prosecution for prostitution. Just a year later today, there are 30 states plus DC. So 5 more states were added to this number of states. This is a growing national trend that is gaining momentum. And by 2024, the Washington state is going to be one of the last remaining state to criminalize youth, if not the very last. Right? Please don't make the Washington state the most backward, regressive, anti-youth state in the country by continuing to criminalize youth who are in the sex trade. Thank you.
Yeah, thank you very much. Next, we'll bring up Marnie Backer, Shravna Sullivanov, and Jason Bragg. And I apologize if I said your name wrong.
I need to give you an apology. It looks like we've signed on the wrong bill. So Jason Bragg and Shravna Sullivanov will not be testifying.
Okay, no worries.
We would like to testify on the 6-month trial return home. So that's the one we want.
Okay.
Thank you.
Perfect.
I'm all alone.
There you go.
Okay.
So yes, all pro.
I've never done this. I'm scared.
Oh, the others turned to pro. That's great.
Okay, that means I
knew I
get more
could do it.
time. Madam Chair and members of the committee, my name is Marnie Backer, and I represent Stolen Youth, whose mission is to end child sex trafficking in Washington State. I'm expressing our support for Senate Bill 5744. This legislation sends a much-needed message that our state will protect every child's human right to grow up free from sexual exploitation. Washington State's current law treats commercially sexually exploited children as criminals, pushing them further from the services they desperately need. Stolen Youth urges the legislature to recognize that these children are not responsible for, nor do they have the capacity to consent to, their own exploitation. They are slaves. The average age of Washington youth is first sexually trafficked is 14 years, and the average age they first received services is 16 years. It's horrifying to think about the trauma that happens to these youth in between these 2 years. We know from Covenant House, an organization serving homeless youth across the Americas, that 1 in 5 homeless youth are victims of human trafficking. And Away Home Washington estimates that there are 13,000 to 15,000 Washington youth surviving homelessness on their own. Therefore, there's an estimated 2,000 to 3,000 homeless youth in Washington who are currently being commercially sexually exploited. The FBI estimates that 60% of the children rescued from sex trafficking were involved with the foster care system. And what about the thousands of kids who are not homeless, not foster kids, but are being trafficked because of the simple fact that they're young and they're vulnerable, making them a target for the insidious people who groom them and then with the goal to sell them to others for sex. Sexual exploitation is often invisible, and knowing exactly how many children are being victimized right now in our state is difficult, but we know they are there and we can't turn away. That is why we support the Safe Harbor legislation's 3-tiered approach to fight child sex trafficking. Services open the gates for minors wanting to escape sexual exploitation, but with no safe places to take these children and not enough trained liaisons to interact with them, the opportunity to escape becomes an even more complicated and grim process.
skipping ahead, Stolen Youth is fighting to end child sex trafficking in Washington, and we also understand that this takes a partnership between government, law enforcement, and philanthropy, which has interest in and supports the issues this bill addresses. We beseech the legislature to take up and pass this critical piece of legislation. Thank you for your time.
Marnie, thank you for your testimony. You gave some very interesting statistics there. I think all of us would benefit from a copy of that if you had,
yes,
could make that available to us. I have another question for you, though, since neither Senator Walsh nor myself, and I don't know about the rest of the committee, participated in these work sessions over the course of the last two interims with the prime sponsors of the bill, both in the House and in the Senate. But I know from prime sponsoring 5290 last year, which will phase out the utilization of detention for groups of individual youth, with this being one of the categories of children that are currently often detained in juvenile justice facilities. And the Superior Court's often thinking that that action of detention is better. Even though it's traumatic, it's better than the trauma of being on the street. And I wonder if in your studies, if you've gotten any sense for whether or not incarceration of a child in these kinds of conditions is appropriate.
I will defer because we commissioned the report from Dr. Deborah Boyer, who conducted it this past fall, and it's a 55-page report with a lot of statistics she gathered from across Washington State, which I will send to you. May we ask Leslie, who's hopefully still here, she may be able to answer that better because she's the expert in the subject matter.
Great. We would probably enjoy getting that electronic link or
Absolutely.
something for that report. Thank you so much.
Thank you.
I don't know if Leslie's still here or not. Do you want to answer? Okay. Quickly, though.
And then while Leslie's coming up, there's also 26 people signing in but not wishing to testify. All in pro, you can take a look online. That's a lot of names, but they're all fantastic people.
Here's the very short answer to your question. Absent secure, therapeutic, appropriate facilities, we have deferred to detention for generations. And so I think that there is a belief that there is a need to have a secure place for law enforcement and for DCYF to take kids who meet the criteria for being put in a secure setting, but we don't have those options. So the belief that we should defer to detention lacks the vision of a response that is truly victim-centered and trauma-informed, and that's what this bill seeks to build. So is it helpful sometimes to put someone in a secure setting? Yes, under some conditions, but that secure setting should never be detention because it should never be considered a crime.
Thank you very much. Okay, with that, we will close the hearing on 5744. All right, we're going to go back to, is Senator Cleveland's not here? We're going to go back to the public hearing portion of 6422, establishing the Family Connections Program. And we have several people again signed up for this bill, and I'm going to warn you right now, we're going to hold to that 90 seconds because we are running, we've already used half our time, so.
Perfect. On the first panel, we'll have Sydney Forrester, Sandra Toussaint, and Karen Goldenberg.
And then can you say who's on deck?
Yep. And then as they're coming up, the next folks will be Katie Byron, Shradna Sullivanov, and Desiree Bird.
For the record, I'm Sydney Forrester with the Governor's Policy Office. Thank you, Chair Darnielle, Ranking Member Walsh, and Senator Wynn, and the rest of the committee members who hopefully will join. Senate Bill 6422 presents a really wonderful opportunity to begin building a more positive culture to better support children in out-of-home care. The Family Connections program provides a means of operationalizing a piece of legislation that has actually been on our books for 17 years, and it is aimed squarely at reducing the trauma associated with a child's removal from home. The Family Connections program was developed in partnership with parents, DCYF field staff, foster caregivers, kinship caregivers, some of whom you're going to hear from today. This is precisely the type of partnership and collaboration I believe that the Blue Ribbon Commission envisioned. It's time to make this very modest investment in the Family Connections program that will help parents and caregivers successfully connect, share information, and better meet the needs of children. Relationships are the agents of change, and this bill is about relationships. Initiating the Family Connections program can be the beginning of building a more positive, reflective, and supportive culture to better support children in out-of-home care. Thank you for your continued support of this child-centered proposal.
Good afternoon, Sandra Toussaint with the Washington Federation of State Employees. I'm here today to generally support this bill. We definitely support what the Family Connection Program is aiming for. We do have some concerns about protecting the integrity of the work that the social service specialists or caseworkers do for DCYF. So while we would like to see this move forward, we would like to see it move forward with an amendment in there, or possibly a new section that states that any contract can only supplement and in no way supplant the work that is currently done by those working for DCYF currently. Other than that, we're definitely in support of this bill and the program and what it's attempting to achieve. Thank you.
Good afternoon. My name is Karen Goldenberg. I'm a court-appointed special advocate in King County.